Hello, everyone. I'm really looking forward to being able to spend a few minutes with you talking today about potential changes to the Employment Standards Act and the Labour Relations Act. In my practice, I have the privilege of getting to know business owners and managers who work in a wide variety of industries, in a wide variety of size of business, providing different kinds of services and products. One of the things they have in common, though, is saying that it's the people stuff that keeps them up at night. Managing people, hiring them, paying attention to their development, paying attention to their engagement in their businesses, and paying attention to all of the requirements and rules and regulations that they really need to make sure that they are in compliance with. So it's important for us to be able to understand what everyone's obligations are and how to ensure that you can do good HR, pay attention to all the rules, and create that kind of engaged workplace that will really underscore a profitable and successful business. So here's what we're going to talk about for the next 30 minutes or so. I'll give you a little bit of background on the Employment Standards Act 2000 and the Labour Relations Act 1995, so named because those were the years in which they were essentially enacted. Talk a little bit about the Changing Workplaces Review, which is the Special Advisor's interim report on the potential changes to these two pieces of important legislation. This Workplaces Review was released in July 2016. A little bit of timeline of changes, what they are saying, people who are in the know about how many of these changes will in fact come to pass, what you could do to prepare for these potential changes, and then a bit of live Q&A at the end. While there are many rules, regulations, and statutes that impact on all of us as employers and employees in the province of Ontario, it's the Employment Standards Act and the Labour Relations Act that impact most of us in our day-to-day lives. The Employment Standards Act regulates such matters as hours of work, wages and overtime, protected leaves, vacation and public holidays, termination and severance of employment. In overtime, for instance, the Employment Standards Act tells us who is entitled to be paid for overtime and on what basis they are paid. The Employment Standards Act also deals with the matter of the definition of employee, and this is an important issue, as we will see later on in the webinar. It's also important to note that employees cannot waive their statutory rights under the Employment Standards Act. So as an employer, even if you were to try to strike a deal with your employees to say that they would work 50 or 55 hours a week for you and not be paid for overtime, they would not be able to actually agree to this under the terms of the Employment Standards Act because they can't waive their statutory rights. The Labour Relations Act regulates matters relating to unions, including who can unionize, how they unionize, and collective bargaining and agreements under various union arrangements. So the Changing Workplaces Review. As I mentioned in the introduction, this 312-page document, yes, 312 pages of information and recommendations, was released in the middle of 2016. It included over 220 submissions by businesses, employer associations, unions, employee associations, community members, etc., on various different aspects of both of these pieces of legislation. As I said, the legislation has been in place for a long time. The Employment Standards Act was drafted in the 1990s, and it was really drafted as a one-size-fits-all type document. Now, about 50% of Ontarians are in some form of what we refer to as non-standard employment. So this is temporary, casual, short-term or fixed-term, or self-employment. This number has increased by about 50% in the last 20 years. There's a societal concern that there are deteriorating working conditions for some of these workers. And so the Changing Workplaces Review set out to see how we could protect vulnerable workers in these, as we refer to them as, precarious jobs. So possible changes to the Employment Standards Act based on this review. Based on our attendance today, I think that the Employment Standards Act probably impacts on most of you more than the Labour Relations Act. so we're probably going to spend a little bit more time on this area. And please be aware that these are simply changes that are contemplated as a result of the review that has happened and the consultation with all of those 220 plus stakeholders. Let's not push the panic button on any of these things happening at this stage. As it relates to pay rates, in terms of the first topic, overtime pay, that time and a half pay, that currently starts at 44 hours, could actually start at 40 hours. Exemptions to being paid overtime pay, such as supervisors and IT professionals, could be removed. Currently, individuals doing the same job on a part-time basis are often paid a lower hourly rate than their coworkers who are doing it on a full-time basis. That differential could be addressed. Your local restaurant server makes a lower hourly rate than a number of other Ontarians, and that's because he or she contemplates a tip or a gratuity as part of their compensation. Those wages could be equalized. Currently, it is not the case in Ontario that you are required to pay your employees when they are sick. That could be changed. There could also be an extension of employers' responsibility regarding Employment Standards Act violations to contractors or franchisors. So in other words, if you have a temporary employee in your company who you're actually paying a temp agency for, that if that temp agency does not comply with all of their obligations as it relates to the Employment Standards Act, you in fact could be held somewhat liable. Vacation pay could go from 4%, the equivalent of 2 weeks, to 6%, the equivalent of 3 weeks. Termination and severance provisions could change. Currently, as I'm sure you know, the amount of money that is to be paid to a departing employee is driven by their service with the company. Recurring periods in employment, we see those in seasonal worker jobs, for instance, do not generally count as continuous service. Therefore, the amount of money being paid to an employee on termination is lower than it might otherwise be. In addition, severance pay is not required unless you are at a certain level of payroll obligation and threshold service, or service threshold. This could also be changed. Perhaps most significantly is enforcement. Currently, there is a requirement for an employee to first contact the employer before going further with respect to filing complaints on infractions of the ESA. This could be changed. So what are some of the possible changes being contemplated by this review to the Labour Relations Act? There'd potentially be an extension on the right to unionize to large numbers of Ontarians who, to this point, did not have that right, professionals such as lawyers, architects, and others, as well as domestic workers. The process of creating a union could get easier, and so a union would no longer require a vote, but simply the process of signing union cards. Employers could be required to provide employee lists to unions, which of course creates some privacy issues. And it could be made easier for businesses with common ownership to unionize. Limits on replacement workers would make it much more difficult for businesses to carry on in the event of work stoppages. So next steps, what they're saying about what's next. This is where we tiptoe a little into the anecdotal. Let's keep in mind that this review is simply that. It's a review. It's a historical survey of what these two pieces of legislation are meant to do, whether they're still working in today's environment. Keep in mind as well that the focus really was those individuals who are in precarious employment, those individuals who are in part-time, fixed-term, etc. The view seems to be that the focus will be on those vulnerable workers. So changes with respect to wage rates might very well go ahead, as will protection for seasonal workers. The others, maybe, maybe not. As it relates to unionization, it appears that the thinking is that more individuals will be able to unionize, but the protocols and the processes for getting there will remain in place. And the timing? That very much is dictated, we think, by the political environment, but certainly it doesn't appear that anything will happen until at least 2018. While we're talking about legislation, a slight aside, the March federal budget enacted various changes to employment insurance benefits, which may or may not impact on you as employers. A new caregiving benefit was enacted, and parental leave, the opportunity to extend a leave to over 18 months, was enacted. However, it is important to remember that this refers to EI benefits, not protected leaves. So in other words, an individual could now elect to take the same amount of employment insurance benefits that they were otherwise claiming over a 12-month maternity leave and turn that into an 18-month leave. However, in order for someone to have a protected leave, a job-protected leave over 18 months, changes will need to be made to the applicable portion of the Employment Standards Act. They have not been yet made. So, apart from not hitting the panic buttons, what can we do to prepare for these potential changes? The most important bullet on this slide, in my view, is the third bullet. It might be the most important bullet on any of these slides. Do good HR. What does that mean? That means that you need to ensure that you understand and comply with all of your current obligations. Make sure that you understand what the Employment Standards Act says and how it applies to you. Make sure that contractors and others also comply. And be very careful about understanding what the definition of employee is. In a number of my clients, they actually have people working for them on the basis of them being independent contractors, which is fine as long as they aren't really employees. Remember the duck test. If it walks like a duck and looks like a duck and quacks like a duck, it's probably a duck. So if somebody comes to your office every single day, gets all of their income from you, says that they work for you, they're really your employee. They're not an independent contractor. And so they have all of the same responsibilities and rights under the Employment Standards Act that an employee would have. So if you have any doubts about that definition of employee, it's a really good thing to look into. I'd suggest that you consider communicating to your employees about their existing total compensation. Sometimes employees don't really realize, not to put it too colloquially, how good they have it. So make sure that they understand that as it relates to additional compensation or additional things that you give them. Do you actually close between the Christmas and New Year's holiday period every year as an additional vacation time for people? Make sure that people understand that there's a value to that. So doing good HR and making sure that everybody knows that you're on the side of your employees, that they are valuable to you, that they're important parts of your team, that'll go a really, really long way. So I hope some of you have some questions now about what all of these potential changes might mean, or anything else as it relates to the Employment Standards Act and the Labour Relations Act. We've had a couple of questions already. One of them, I love the tone of the first one is, I have to pay how many sick days? So I certainly was aware that that might raise some eyebrows. And the answer is, if this is enacted as part of the ESA, there will definitely be a structure. You would be required to pay a certain number of sick days. It could be related to service. And you certainly would always have the right to have an attendance policy within your policies that dictates the information that you are required to have. So you can, in fact, ask for doctor's notes. You can ask for support for the person's illness, as long as you actually have a policy and you apply that policy consistently. Which of course is the key with most of these policies. I see there's a question with respect to franchisors and contractors as well. In the slides, I talked about how important it is that you make certain that those individuals are complying, and the question was, how do we do that? Well, great question. My suggestion would be that if you have engagement letters or contract letters that you actually use to engage a contractor, that you actually ensure that it is specifically noted in that document that the company providing the contractor or providing the temp worker is in full compliance of all employment standards regulations as it relates to that employer, and make certain that the employer does in fact sign off on that. So if you do have somebody who's working for you on a temp basis, best to not do that on a handshake. Best to make sure that you have some written documentation in place. Not a question, but something that I often, and it kind of goes to both of the first two questions, that I often talk to my clients about. A number of my clients are small to medium-sized businesses, obviously, and one of the reasons that many of you are in a small to medium-sized business is that you don't want to spend tons and tons of time on lots of bureaucratic policies, and so sometimes there's some resistance to having a policy with this or a policy about that. But the one thing that I would say is, having policies and having structures means that you aren't required to make ad hoc decisions all the time about everything, and it also enables you to ensure that you're managing your employees consistently. And the more regulations that we are subject to in Ontario, and whatever changes end up happening with respect to the ESA, will provide more structure. The more we are subject to, the more advantageous it is to us to make sure that we've got some policies in place and that we have individuals who are monitoring those policies. There was a question regarding the definition of employee. So I won't repeat the duck analogy again, but that's a very old analogy. It's a very, very tricky question because particularly if you are working in a small to medium-sized business, you might have individuals who would like to work for you on a contract basis, therefore, not to have you withhold any federal tax, perhaps for them to be able to avail themselves of some small business deductions, et cetera. And that's all completely fine as long as you make sure that, again, not wishing to reference ducks again, that you have all your ducks in order as it relates to that arrangement. So you would want to ensure that you paper the arrangement saying that it is not an employee relationship. There'll be no withholdings. There should be no entitlement to paid vacation time or paid statutory holidays or anything like that. So anything that makes it look like an employee relationship, you should ensure that you are not doing. You also need to make sure that they are charging you HST, depending upon the level of income, and you really need to ensure that they are in fact legitimately getting potentially their income from another source. So having someone work for you for 5 years and getting all of their income only from you, is not going to bode particularly well as it relates to justifying that this is in fact a contract or a relationship as opposed to an employment relationship. I have actually dealt with a client who ended up with who in fact, it was really quite a unfortunate situation. They in fact responded at the request of the individual to pay the individual as a contractor, but then when the relationship did not end on the happiest of notes, the individual then went back to employment standards and maintained that the company owed him a whole bunch of vacation pay and overtime pay, et cetera, notwithstanding he had in fact agreed to work as a contractor, but I'm air quoting. So keeping in mind that the Employment Standards Act indicates that someone can't contract out of their statutory rights. So that would have been a case where making certain that we had all of our documentation in place and making sure that we really understood what the relationship was all about would have actually really helped down the road. There's one more question that I will answer shortly and it's probably a fun one for some businesses. But if there are any other questions, please feel free to submit them through the widget. So I have a question with respect to my reference to servers and that hourly rate. So any of you who've ever worked as a server or has a kid who's worked as a server knows that the hourly rate is generally lower than, or is lower, almost always lower. And the contemplation here is that potentially that might be done away with. Now, I worked for 5 years in the hospitality business, so I certainly know that it's a business with low margins, and that essentially, if everything is required, if the grats and the tips stay in place, but your local neighborhood restaurant is required to pay your server at the full minimum standard hourly wage, you can probably anticipate your pint of beer going to about $20 a pint, which is probably not something that would make anybody happy. So I think that there definitely will need to be some real consultation on what this means for the food and beverage industry, and it could very well be, it might even go to a fundamental restructure of how individuals in the hospitality business are compensated, because it's simply, I know that it may be popular for a server to say that somebody running the restaurant is making tons of money off their backs, but I can tell you that, having had lots of friends in that business, it's not a business that they do make tons and tons of money and overall, and there's lots of expenses. So it will be something that they will have to look very seriously at. So any of you who are thinking of going into the food and beverage business, if you're not already in, you might take that as a word to the wise. So. Okay, so I think that's all the questions. If you think of anything afterwards, I would be delighted to connect with you by email or on LinkedIn. We will all watch this legislation or this consultation and see how it turns into legislation. Absolutely not going to make any political comments, but clearly that all of this exists in a political environment, and so depending upon the ruling party and what kind of reach out they want to do to potential voters, that could in fact drive what may or may not happen as it relates to a number of these suggestions. So thanks again for your time. I appreciate it. Enjoy your afternoon, and I'll look forward to hearing from all of you if you have any questions. Thanks very much.